Hey there and good morning. Welcome to another exciting edition of Business Law 2015. Here we go. Yeah, this is the end of week 8 if I'm not mistaken. We're down to 7 weeks remaining in this semester. You guys have finished half your tests. The previous test, it kind of looked like the average scores were similar to the first ones. I think as you guys are finding, I think as I said towards the start of the semester, the tests are rather difficult. There's no question about that, and I know some have expressed concern about the time limits, but I remind you that in a face-to-face class, I give very similar tests, and they're limited to 50 minutes with no books, no notes, and so my expectation by limiting your time is that you got to get in there and do the test, hopefully without, and I'm not there to observe you, but hopefully without the aid of books and notes and those types of things. So, and that's why I set the time limits. So, we're discussion. Yeah, I was going to talk about the discussion because we've picked up the pace a little bit. Good. I'm not sure what the group is that we're on, but maybe I found a topic here that was of interest to you all. I got to get going here. I got a few more, obviously that'll be coming up, but the 4th through the 11th here. We had about the cocktail waitresses. Got a few people kind of riled. Yeah, and it's really talk about one of those gray area topics. What can employers do and what can't they do, and the standards are well, they're not. I mean, it's truly a huge gray area, and you guys hit upon some of the issues. I think when we get into that chapter, those chapters that talk about employment discrimination and whatnot, I think we'll talk about some of the other issues. But truly we find that there is no set standard. That I guess the best thing I can tell you, and I don't know if this will clear it up at all, it might make it murkier even, but the best thing that I can tell you is that in general, businesses are allowed to set some standards about appearance and those types of things if those standards have an effect on the business, okay, the ability to attract business, or safety, of course, okay, and so those things become big issues. A case, give you an example from the safety side. Anyhow, Greyhound buses years ago, they set an age limit. Actually, it was a upper and a lower limit as to where they would hire drivers, a certain age, and they got sued saying that was discriminatory. But Greyhound had reams of data that showed that drivers of certain ages are safer drivers, and to them safety was of primary concern, and in the court they won their case. Okay, now you guys looked at this one. We were talking about the cocktail waitresses and them, maybe not. They were hired and met the appearance requirements, but then as time went on, they failed to meet those same appearance requirements, and thus were, sent packing. And of course, we looked at the Hooters comparison, and Hooters has endured a decent number of lawsuits. I think somebody pointed out that a lot of times they settle, and sometimes they do. Now, if you go back to one of the first cases against Hooters, though, what you would actually find if you read the case, and it did settle also, so you might say, see, Hooter settled, but the truth was it was actually the and I don't remember if it was the Justice Department or one of the state attorneys generals that settled with Hooters, okay, because the case was going poorly for the plaintiffs, or it had to either be the EEOC or one of those that had carried the lawsuit, and they settled with Hooters because the case was going badly. Hooters was proving that the appearance standards that they had were very, very extremely important for their business. And look at the businesses that we have in the U.S. and where appearance can make a difference, and Victoria's Secret. Well, we don't see too many runway models that are a little bit bigger size. Although that's starting to they're starting to do more and more of that. I think as the U.S., as our overall waste lines are expanding, I think we're seeing a push toward that. And I think some of you might have mentioned Playboy. I was just reading an article about Playboy. They've decided to get away from nudity in their magazines, I think, is what I read. But very similar situation. If they have chosen, I should say, to feature models that typically have a certain body type, and that has been apparently important to their business. Now, as a guy, I'm going to refrain from really passing judgment on whether or not I'd buy it, otherwise, but I have to admit I don't buy Playboy anyways, but and I'm not going to pass that judgment. So we allow businesses to make some of those choices when it is important for the business. And on the other side, and we would call those also BFOQs, or bona fide occupational qualifications. On the other side, some of you maybe correctly pointed out that look at certain look at our military. We did have a couple gals just pass the Ranger test. Okay, but prior to that, it's all been guys, and there's been a lot of gals that have tried before that have failed. Okay, and so there's a certain standard there that we set for folks in order to engage in that type of a job. Is that so much different than requiring that? I mean, obviously those people are required to work their tails off, to stay in shape and to stay physically fit, and on and on and on. And if they don't, they're going to get booted, right? Is there a lot of difference between that and having a job where a female then is required to maintain a certain appearance? Okay, yeah, I mean, yeah, I can see both sides of the argument. That's why it's a gray area, and that's why they're decided on a case-by-case basis. Now, other side of the coin, and you guys didn't find you found another Abercrombie and Fitch. I think it was reference to what their CEO had one time said about ugly models or something. But there was another case, Abercrombie and Fitch, if I'm not mistaken, declined to hire, I think, if I remember right, unless they fired him afterwards. And that might have been the case. They might have hired him, but then told them they couldn't wear burqas. Okay, and a burqa is a headscarf that are worn by people of the Muslim faith, and they said that they weren't allowed to wear those to work, and they said that it didn't fit the image of the company. Now, in that case, the Abercrombie and Fitch lost. Okay, and Abercrombie and Fitch lost because they were unable to prove that that was important for the sales of their product, in their stores, and so they couldn't do that. Again, gray areas. What side of the issue do I come down on? I guess it would depend on a case, just like it does with the courts. So, yeah, let's talk about tort then, and talk about all these lawsuits and whatnot that happen, because many of them happen because of tort, right? And so we'll start from the beginning. We're at chapter 10, and tort. I think you guys had a question regarding, defend your position or your ideas about tort reform, because it comes up all the time. It has yet to come up in the political discussion. They're busy talking about illegal immigration and a few other things, but tort often comes up in the course of a political campaign. And so between now and a year from now, a little more than a year from now, we'll probably hear some discussions about tort and tort reform. And tort, a civil wrong other than a breach of contract. So what's that mean? Well, I think that we'll define that a little better as we go along here. But it limits how people act and use their resources, and we're free to act, right? In the United States, we enjoy a great deal of freedom, but we also have a duty of care, and that's, I think, when we come to. So tortious behavior results in torts. So obviously, if you fail in your duty of care, that results in tort. And a tortfeasor, I've looked that up, and that doesn't show up when you look it up normal, so it must be just in our textbook. But it's just a great word. I just like tortfeasor. I like to use that word. But anyhow, Yeah, this idiot that was driving the truck or whatever that lost all the beer, horrible tort, horrible. You know, he should be thrown away, locked up, and the key thrown away. Let's do that. So we got three types of tort. Anyhow, there's intentional, negligent, and strict liability. The vast majority of the ones that we see, you know, the cases and whatnot that are brought, tend to be of the negligent type, but certainly we'll talk about intentional and strict liability. So, what do we see, right? Yeah, 60% roughly are auto accidents, and again, a lot of these we don't hear a lot about. You know, somebody runs a stop sign, they bash into Johnny. They don't even go to court, right? The insurance company for whoever, you know, the defendant, you know, the person that was wrong, you know, writes out a check to the plaintiff, the other person, and I shouldn't call them plaintiff and defendant because legal action oftentimes never even gets started. You know, one insurance company pays the other person and covers them, makes them whole, gives them complete compensatory payment. Boom, it's a done deal, right? So we don't see a lot of those. Dangerous property, ooh, you know, dangerous property. So what's that? Slip and fall, maybe, right? So I'm in shopping at the local supermarket and I fall on, you know, their slippery wet floor, right? Okay. Product liability. Those ones, you know, obviously we see a lot of those. You know, they tend to be huge because we get to sue the, you know, the company that makes it, and so they oftentimes get to be pretty huge. Toxic substance. You know, probably think. I'm guessing, and I don't know. This may cross between product liability and toxic substance, but drugs and whatnot that you might take that. You know, maybe to solve one problem but end up causing another problem. And then, of course, medical malpractice. So we hear a lot about those. You know, why don't we see a lot of tort cases? I mean, there's really tons of tort things that happen every day around the country, but you know, most of them just settle. Again, you know, think about to the minor car wreck, you know, the little damage that happens. You don't even think of it as being a tort, even though it really is, because you know the system works, it gets in place, it solves the problem, and everybody goes about their merry way. And then a bunch of them are dismissed. You know, there's actions that are brought, and they get dismissed. The judge maybe feels that the plaintiff doesn't have a case. Look at that. You know, it's hard to even see how little that is, but a jury verdict and then a bench trial verdict and then unknown. And unknown, you know, probably falls into this settlement type of thing. But because we don't have to publish often, you know, the unknown, the settlements and whatnot, you know, those don't become public domain types of things if there's a settlement. One reason people settle so often, right? And so my guess is that that's typically what those are. So intentional torts, right? It's a deliberate action. So somebody thinks about it, premeditated maybe that's a little harsh, but a deliberate action that causes injury. Either a desire to bring about certain results, or the results are substantially likely, or obviously if the results actually end up happening, right? So intent is described as that, right? Desire to bring about certain results. We've got assault and battery, and I think sometimes we tend to, maybe we don't use the term battery very often, but assault is actually defined as threatening somebody, and in a real enough way that the person believes that it might happen. That's really an assault, even though you haven't physically touched the person, maybe. Okay, battery is when you actually haul off and, you know, hit somebody, or you know, go out and cause some physical damage, right? Okay, infliction of mental distress is you know, again, think maybe older people that are easily manipulated, but it might not be just older people. It could be others too, right? And we might hold something over somebody's head, right, and cause some duress or distress, you know, for that person that might be not perfectly legal. It might be unintentional. If it is intentional to cause that harm, certainly that's going to be tortious behavior. Invasion of privacy, trespassing. those types of things, right? False imprisonment and malicious prosecution. You know, you'll see that occasionally. A store might stop somebody for shoplifting and they didn't actually shoplift, and if they hold them and do that, they might get sued for false imprisonment. And we see, police departments sometimes getting sued for that. And malicious prosecution could be, somebody trying to push their rights in court and doing so inappropriately. Trespass, again, kind of an invasion of invasion of privacy might be dealing with more intangible types of things. I should come back. I said trespass might fit in that, but think about people hacking into your computer maybe and whatnot, which is a type of trespass. Trespass might be more the physical, where they actually come into your yard and they're not supposed to, or enter your car. Guy stumbles out of the bar drunk and opens up and climbs in your car by mistake and falls asleep. Technically, that's a trespass, right? Conversion is using another's assets inappropriately for your own gain. You see this happen with caretakers, again, oftentimes of older or infirm people who might have substantial assets, right? And so instead of using that to pay for Uncle Art's care at the local care facility, you use the money and go to Hawaii because you want to see a conference on the aging people that lasts all of a half an hour, and you spend 3 weeks down there. Yeah, okay, that's kind of my definition anyhow of conversion, right? Defamation. Yeah, that's when we publicly say things or write things. Okay, slander or libel. Okay, we write or say things that actually harm folks. Okay, and harmful, harm them, and maybe what we're speaking is the untruth, right? Okay, saying perfectly truthful things about people, okay, usually gives you a certain degree of protection, right? If you're a restaurant critic and you go to a restaurant and you don't like the food and you write about it, and you say, hey, I didn't think the food was very good, and here's why. Pretty tough to. They can certainly sue you because anybody can sue anybody anytime for anything, but probably not going to be successful. Now, if on the other hand, Joe's got a restaurant down the street and it's competing with mine, and I start the rumor that Joe uses bad things, for lack of a better term. I don't want to be too disgusting, but bad things in his recipes. And if it's not true, that could certainly be defamation then, and I could be held accountable for that. Fraud and corporate governance, okay, and common law business torts. I think we talk about that a little bit later, if I'm not mistaken. We don't talk a lot about the common law business torts, but that's businesses causing harm to others, right? Here we go. Injurious falsehood, right, or trade disparagement. So again, saying things about your competitors that aren't true, and it causes injury, right? Or intentional interference with contractual relations. And as you might imagine, there's a lot of contracts in cities and whatnot that involve all kinds of different parties, and so Party A contracts with Party B. Party B is going to provide some services for Party A, but Party C has often had Party B providing those services, and C doesn't like the fact that B is going to provide them for A, and so C kind of twists B's arm and says, don't do that, or don't, or slow it down, or do those types of things, right? And that could be intentional interference. So, okay. Cyber torts, kind of a new thing, right? Defamation. We can get on and say things, and we're seeing more and more of that, and can you, if you work at Walmart, can you go home and put, Walmart sucks on your Facebook page? Well, yeah, the courts have kind of said that's probably okay, and Walmart probably isn't going to be able to fire you. They might not like you much for that, But, can you disparage untruthfully? There again, maybe not, especially if it causes some harm and whatnot. Okay, intentional infliction of mental distress. We've seen that. I think there's been a couple high-profile cases where people have actually committed suicide or those types of things because there was mental distress. Hackers, misappropriation of trade secrets, those things, right? And fraud, of course. Don't need much more explanation. Negligence, right? Unreasonable behavior that causes, and this is the most common. Okay, I mean, we're all aware of intentional torts that happen. Again, assault, those types of things. By the way, too, it certainly would not be inappropriate to say at this time that you can absolutely, there can be a tort and a crime. Okay, and absolutely it's the same incident, right? And you got a civil case and a criminal case, both going side by side. Happens all the time. I mean, really, every crime that's like that is also a tort. I say every crime, and I'm trying to think if there might be an exception to that, and there may be, but for the most part, every crime is also a tort, right? And in those cases, it's almost always a intentional tort. Somebody intended to rob or steal or trespass or do those types of things, right? Kill or anything like that, right? They're both a crime and a tort, so that's important. Negligence is the most common, okay? You need these four things really to have a negligence case to be successful in bringing it. There first has to be a duty of care. Okay, and to a certain degree, we all have a duty of care. If we're driving down the street, for example, we have a duty to drive in a safe and prudent manner, right? And if we fail in that, then we may be held accountable. Tort law, okay? But oftentimes it involves more, the doctor for the malpractice. Although you saw that, automobiles were, I guess, the most common, but it might be something that we do in our work too. We have a duty of care. We breach the duty, right? We end up in unreasonable behavior, so we drive imprudently, okay? And causation, our failure or breach of our duty of care causes, right? Something causes some damage, causes some harm, right? We talk about in fact and proximate, and in fact would be, I think the book describes it. If I was driving imprudently, hit a car, caused the accident, obviously to the car and maybe the occupants, but if a wheel comes off and rolls to the side and hits somebody on the sidewalk, that would be proximate, okay? And I would, in fact, because I had a duty of care, I breached that duty. And my actions caused both the factual and the proximate harm, would be held accountable for both of those. And then damages have to occur. There has to be some level of damages, right? We do things. We all have a duty to drive correctly, right? We breach our duty often, right? But doesn't necessarily lead to causation that causes damages, okay? And so that happens. And that happens with a lot of other behavior. And sometimes we might even cause some, some bad feelings or those types of things. But does it equal damages? And that's where courts come in often. So kind of got ahead of ourselves, and we pretty much already talked about that. There can be a willful and wanton negligence. That's a little higher bar. Again, we have causation in fact. That's hitting the car. Proximate causation is other things that happen as a result. Can there be affirmative defense as well? Contributory negligence, and then comparative responsibility. So not all things are as easy, well, it was that person's fault. Not all things are like that, and getting back to our car example, I might run a stop sign and cause a problem, but maybe Johnny was driving, 55 miles in a 25 mile an hour speed zone, okay, speed limit zone. So then, right, now we might have to see who's most at fault, right? That maybe the fault lies with both parties, and you might imagine a lot of times when that would be the case. That there's a lot of times when both parties might have some degree of some contribution anyhow to the accident or what might have happened, right? Assumption of risk, and we do that. I mean, most places, businesses, those types of things, especially those that have some level of danger, maybe they put up signs, right, and they have you sign agreements to say, hey, you know that this is a bit dangerous, right? And there is an assumption of risk. For example, I like skiing, and so when you go skiing, if you go to Showdown and you ski and you're coming down Dynamite Run, which is pretty gnarly. And you have a wreck and you break your ankle, and you just wrecked in the normal course of events. Yeah, you're probably you'd have a tough time bringing a case against Showdown in that case. Now, if there was an unmarked hazard that should have been marked, different story, right? Okay, because then Showdown had a duty of care. They should have marked the hazard, and they didn't. And if the hazard caused your injury, yeah, okay. So that hopefully explains kind of what assumption of risk can be and whatnot. So then we get to strict liability, right? Strict product liability, right? Dangerous or defective products, right? There can be production defects, design defects, or warning defects, and people are going to be held strictly liable. Companies, businesses, whatever, will be held strictly liable for that, right? The railroad, and I've used to have, they made it too difficult for them to come in anymore, but I used to have claims reps for the railroad come in and talk to my face-to-face business law class, and it was always kind of interesting. One of the things that they said, for example, for them was strict liability. If their train's going down the track, you got metal on metal, it kicks up sparks, right? They start a fire causes damage, strict liability, right? They drive their trains through places that are basically an open range. The railroad has a responsibility to fence off their right-of-way. That's actually the railroad's responsibility to do that. Okay. They have oftentimes said that it's cheaper to pay for a cow every now and then than it is to actually build the fence and maintain it and do those types of things. And so again, it's a strict liability. If they hit a cow in a place like that, they're going to write a check, right? Okay, and so that's in providing a service. But you'd see that with certain products. If they happen to be defective, there's going to be some strict liability, and they'll be held accountable. Think of drugs again, right? That they get prescribed for something, but one of the side effects causes more harm. Okay. The doctrine of, and we get back to that respondeat superior, you're responsible for and you're going to be held accountable for the conduct of your employees if they are acting within the scope of their employment. Okay, and ultra hazardous activities. So the guy that sets off the dynamite to bust up the rocks for the road construction and whatnot, if that blows a chunk of rock, further than he expected, and it hits your car and breaks the windshield, they're going to have to pay for your windshield, right? Other strict liability towards dram shop tax, probably be on the test, right? Tavern owners can be liable for, the actions of their patrons that get too intoxicated. That's a tough deal for bar owners, to be held accountable for the actions of folks, and what about the guy that he's been partying down the street and he staggers into your bar and has one drink, and then he goes out and does something bad, and it's your bar that might be held accountable. You were the last ones. Is that fair? Yeah, I don't know. And again, they leave that up to the courts and those types of things. So common carriers are held strictly liable, right, for damages to goods, except if there's an act of God. So a bolt of lightning hits the truck, right? Fire. We've seen fire up at the, maybe the fire prevented a truck from getting through, and they were hauling some produce, right? And the produce ended up spoiling because couldn't keep it cold enough or something, right? Could be considered an act of God. Action of an alien enemy, so you get attacked. Order of public authority, again, that could be a road closure for other reasons besides nature. Okay, different things like that could happen, right? Inherent nature of goods. So if I'm shipping something, I've asked a trucker to haul something that is dangerous. Okay, then he's going to have an exception then if those goods get damaged. And then the misconduct of the shipper, kind of the same thing. If I don't tell the trucker, exactly what's on there, if I have a responsibility to package it in a certain way and I don't, okay, that could be considered misconduct of the shipper, and so the truck driver in that case, or the trucking company, wouldn't have any liability. Compensatory damages are those damages designed to make a person whole. Okay, so if I wreck your car, and it's a simple little car accident, and I go through the stop sign and hit your car, and I cause $3,000 worth of damage, my insurance company writes you a $3,000 check, it's a done deal, right? You've been fully compensated, assuming there's no injuries or anything like that, just a minor little fender bender, right? I might hit your parked car, right? So there wouldn't be any. Okay, punitive damages, and we see these in the big cases, and usually the big numbers that you see are punitive damages. Even if somebody dies, typically we're seeing those awards, maybe $1 million to a couple $1,000,000 or something like that for somebody dying. They figure that's the worth of a person. Well, that sounds kind of sick and demented that somebody has a worth, but I don't make those rules. Juries and judges do, but then you'll see a big amount, they get awarded $26 million, right? And oftentimes those are the punitive damages, and what they're saying is that the behavior of the defendant may have been so egregious that they need to be punished for their actions, and so that can get to be a big number sometimes. And I don't know if I asked you guys to find an example of a tort case, but you'll see. I think if you go back, the most common one, by the way, if you find this, and everybody, not everybody, but about half usually I get, are the old Stella Liebeck. When you look up outlandish torts, the old Stella Liebeck and McDonald's, and our actual damages were about $20,000 medical care, which McDonald's refused to pay. Ultimately, the headline number was, I don't know, 3-4 million or something like that, which everybody says is outlandish. If you read on, and you really got to look for this, but even after that award, they ended up settling out of court for something substantially less than that. Okay, it was far more than the $20,000 that Stella had originally asked for, but it was far less than what the jury's award had been. So, okay, again, compensation can include these types of things, right? Past, future medical expenses, certainly. Past and future economic loss, obviously, you're missing work, right? You can't provide for your family, those types of things be covered. And past or future pain and suffering, and that's where the calculation gets difficult. And future, of course, estimates on any of these things gets to be difficult. You get whiplash in a car wreck. Well, you feel okay a week later, but does that mean that you're not gonna have neck pain 20 years from now that may have come as a result of, right? We're starting to know that injuries to joints and whatnot when you're younger gives you a higher propensity of having arthritis as you get a little bit older. So how do you calculate those things? I don't know. We leave that up to juries, by the way. So punitive damages, again, are used to punish defendants for bad behavior. We oftentimes, again, will see that in regards to against bigger companies and whatnot. Getting a punitive damage against an individual sometimes is kind of worthless because they're probably not going to have the dollars to pay it anyways, right? Nor the insurance coverage to pay it. So again, it has to involve negligent behavior that's gross or willful and wanton, right? So somebody's really gone out of their way and they've just ignored maybe warning signs and whatnot, those types of things. And the damages are exemplary, meaning that they're designed to make an example of the company or person, right? So we got tort reform. You know, there's things that are in place, and additional things that um, continue to be put on the voting block, I guess you would say. So, actions against retailers or wholesalers unless the manufacturer is insolvent. So, if the product's bad, you bought it at Walmart, okay, you might actually sue Walmart. Walmart might get the third party, right? But what this is saying is you might have to go just to the actual manufacturer, right, and sue them, which probably gets interesting when you're talking about foreign companies and those types of things. I imagine there's procedures to do that, but I would also imagine it gets to be a little more difficult. So yeah, no recovery for a defective design. That's kind of weird. That one I don't know that I fully understand that one. Okay, and as a part of a tort reform, right? You would think if something was defectively designed, that there could certainly be recovery for it. Unless you make changes, and that might be what they're talking about, right? If you make changes to that design or whatever. No claims against sellers if that's the next one, though. No claims against sellers if the product's modified by the users. And we've seen that, with vehicles. They soup them up, they do other things, right? Change the tires, and they don't go with the recommended ones and things like that. Yeah. State of the art is a defense, basically says that, hey, we made it to the highest standards of the time, right? So it was state of the art at the time, and yeah, standards have changed significantly, but for the time it was the best it could possibly be. And that's a defense. It's a defense that gets used, and of course possibly considered for tort reform that would make it an absolute defense as opposed to just one that's brought up, I guess, in case. A statute of repose, and we do have some statute of repose, and what it would do is impose it maybe in other areas, and the one that I remember for sure is small aircraft. For the long time, the U.S. had a real vibrant small aircraft industry, made Bonanzas and Cessnas and all those, and a whole bunch of those started to go out of business, and the reason is that they were finding that these people that wanted to fly, but they couldn't afford expensive or newer planes. They were buying these planes that were 50 years old, 40, 50 years old, and they were still flying them, and sure enough the plane would wreck, and they would find out that some parts had gotten worn out and tired, and that's why the plane wrecked, and they were suing and winning, okay, even though the planes were that old, and the small plane manufacturing in the U.S. just about went completely under, and Congress finally passed a statute of repose in that case that said, you know what, if it's over 25 years old, if the plane's over 25, you got an assumption of risk there, I think would be the proper term, right? Reduce or eliminate punitive damages. We see this a lot with medical, that there's a lot of medical malpractice that happens. There's doctors that make errors in judgment, and always we wish that didn't happen, but unfortunately doctors are human. Some of the punitive damages are huge, and it's also made their malpractice insurance obviously huge, which just increases the expenses of all our medicine for all of us, right? And perhaps if we limited the punitive damages, not the compensatory, right? So the doctor operates on the wrong leg, you're going to you should, and you will, still get fully compensated for the actual damages that happen, but the punitive damages might be limited to a set amount. So we talk about, right, disadvantages of the tort system. It's expensive, right? And attorneys, there are already ads on TV for attorney. If you bought a Volkswagen diesel, you may be entitled to compensation. Okay, I saw ads a week ago. This scandal's 2 weeks old, and there's already ambulance chasing attorneys that are out there, right? And they're willing to take the case, right? And they'll sign you up, and they'll take the case, and they'll start early. They'll probably combine forces with all attorneys, and they'll create this great class action lawsuit and against Volkswagen, which they're obviously going to win. I mean, Volkswagen's at fault, and they'll get compensated greatly for it, and away they go. And so that's one of the disadvantages, I think. Not that Volkswagen doesn't deserve to get taken down. They cheated the system, right? So they deserve some criticism, and they deserve to get sued and whatnot. But alternately, you might say in another system, you might just have an ombudsman or a government agency that comes in and says, hey, Volkswagen, you screwed up, you're going to fix it, you're going to make everybody whole, and you're going to pay them, give them all $1,000 too, or something like that, right? And it'd be a done deal, okay? And that would save a whole lot of time and effort on the judicial system and all the lawyers' compensation and those types of things. And so, when we say that it's a disadvantage to possible alternatives out there. Some of the alternatives include this, right? Just going to arbitration. Okay, so instead of having this costly lawsuits and whatnot on the Volkswagen thing, just say, hey, we're going to get an arbitrator out there, and they're going to make an award, and that's going to be that. No-fault insurance. We see this with automobiles. Some states are actually no-fault insurance, meaning that it doesn't matter if the person ran the stop sign and hit you. Your insurance company actually pays then for your repairs, and nobody gets hurt, I guess, and we see that in some cases. Workers' compensation is actually a type of no-fault insurance. Okay, it doesn't matter for what reason you might get hurt on the job, even if it's your own fault, even if it's your own error. Okay, you're entitled to some compensation and replacement of pay and those types of things, just based on the fact that you work there, right? Again, even if you might have been at fault. I just talked about that, right? Protects employees' families, right? It says if the employer acted unreasonably, but it doesn't have to be unreasonably. The employer may not have had. I'm not sure why that's in there. I should maybe take that out, because the employer may not have acted in any. You may be the one that tripped and fell over your own stupid feet, right? Maybe you're wearing new shoes and you didn't realize they were ½ inch longer or something. I don't know. Defenses. Again, contributory negligence, yeah, maybe. And I think it depends probably from state to state on the workers' comp. Ours, here in Montana, ours is, I think, truly no fault. Some federal, okay, like, and railroaders are covered under the federal FLA, is it Federal Liability Act or something like that? It's a little different than the workers' compensation in our state. Okay, and they can have contributory negligence. So if the employee does something incorrectly, yeah, they may not be entitled to an award, right? And obviously, if the employee does something intentionally to get hurt, and yes, that happens. Okay, workers' comp's not going to cover them in those cases either, right? Test for compensation injury if it's an accident, again, instead of self-inflicted on purpose and a result of employment. That's generally what we see. And then, like in Montana, that's an exclusive remedy, meaning that, hey, in fact, you guys noted early on that we have a separate workers' comp court, right? That's going to decide these things. Boom, that's it, right? It gets decided, and it's a done deal. So many states have enacted or considering laws, right, classifying certain breeds of dogs as dangerous. Rottweilers, Dobermans, Pit Bulls. Would that be a strict liability? Yeah. If so, yeah, knowing you might be held strictly liable should you have that type of a critter. And interesting, isn't it, that, again, it gets to individuals. We oftentimes think of that in terms of businesses, but it could be individuals. So, good enough. I'm getting a little better, a little quicker, 43 minutes, so hope I covered it well. I hope you guys do well. Keep up the reasonably good work. I'm glad to see the increased effort here. I'd encourage you to, more is better, and more research and those types of things is always better. Next week's topic is lawsuit. A little bit of a funny one. Lawsuit claims man's flatulence prompted firing. So again, what type of reasonable, so here's a term I want you to look up, and again, you're probably going to have to look ahead a little bit, but what type of reasonable accommodation needs to be made? Okay, maybe even think, I'm going to stretch this one a little bit. Think about that in terms of The clerk in Kentucky who denied and has continued to deny licenses for same-sex couples. And then ask yourself the question about reasonable accommodation. I know they seem completely opposite and whatnot, and I don't know if there's a connection. I really don't. I do know that that's a subject that has been brought up by some of the conservatives that support the gal in Kentucky, Kim Davis, I think her name is. So we'll enjoy. Everybody have a good week, and we'll talk to you next week.